Have you ever paused to consider the unseen forces that keep the lights on?
Mhm.
I mean, not just the flow of electricity itself, but that whole intricate web of rules and regulations, making sure it gets safely to your home or business.
Yeah, it's something we often take for granted, isn't it?
Totally. So today, we're taking a deep dive into something really foundational, but maybe often overlooked, the Electricity Act, 1992. And when we talk about prescribed electrical work throughout this deep dive, well, we're talking about those specific electrical jobs, the ones designated by regulations as being particularly risky.
Uh-huh. The ones needing strict oversight because, well, the risks are just inherent.
Exactly. This act is really the backbone of electrical safety and accountability in the country.
And what's truly fascinating about this act, the 1992 one, is how just this single piece of legislation maps out the entire framework, for safety, responsibility, professional conduct, the whole electricity sector. This document, it's not just some dry legal text. It's more like the actual blueprint for a safe electrical environment. It touches on everything from who can install your wiring to, say, the responsibilities of the big power distributors and even what happens after a serious electrical accident.
Right.
So our mission today really is to pull out the most important nuggets of knowledge, the key insights from this legal landscape, and make sense of how it impacts our daily lives, because it really does.
Exactly. We've got excerpts here from the official reprint of the Electricity Act 1992, and this version's updated as of December 1st, 2020, so it's pretty current. And like you said, this isn't about memorizing clause numbers. It's about understanding the protections, the obligations that keep us safe and well informed when it comes to electricity. Yeah. So let's shed some light on how this vital resource is governed. First up, let's talk about the primary guardian of electrical safety, the organization really tasked with ensuring our well-being when it comes to all things electrical, WorkSafe. Their role is clearly central in this act. So what exactly are WorkSafe's main functions under this legislation?
Okay, so WorkSafe New Zealand, established by its own act back in 2013, has this really multifaceted, critical job under the Electricity Act. Their core functions, well, they include carrying out inquiries, tests, audits, thorough investigations, all aimed at determining compliance with the Act's rules.
So checking that people are actually following the law.
Precisely. But beyond that, they're empowered and actually responsible for taking all the necessary lawful steps to ensure the safe supply and use of electricity right across the country.
Yeah.
And they also perform various other duties specified in the Act. It's a really comprehensive role. Covers both, proactive prevention and reactive investigation, which really highlights the high-stakes nature of electricity.
That sounds like a huge responsibility.
Okay.
And I guess to carry out those functions, WorkSafe must have some pretty significant authority, especially when it comes to actually getting hands-on with inspections and investigations.
Oh, absolutely.
We're talking about powers outlined in sections 6 through 8 and then 16 through 20. Like, what authority do they have during routine inspections? What are they looking for?
Right. WorkSafe has considerable power to inspect, well, pretty much any part of electrical works. Think power lines, substations, that kind of thing.
Hey, big stuff.
Yeah. And also electrical installations inside buildings, appliances, any associated gear, really. And they can do this at any reasonable time. They can enter and re-enter any place for this. But the Act does balance this power with fairness. For routine inspections, WorkSafe has to give reasonable notice to the person in control of the gear and the occupier of the land they're entering.
So they can't just show up unannounced for a routine check.
Not for routine checks, no. It ensures transparency, lets people prepare. It's not meant to be a surprise raid, usually.
And it seems they have some particularly strong special powers, too, beyond just like a visual check. Section 8 mentions they can require someone to take apart or dismantle any fittings. That sounds pretty significant.
It is significant, and that power to demand dismantling is crucial because, a lot of electrical defects or non-compliances, they aren't visible on the surface. They might be hidden inside conduits or behind walls or deep inside some complex machine.
Right. Hidden dangers.
Exactly. So this provision lets WorkSafe uncover those hidden hazards. It ensures a really thorough assessment that you just wouldn't get with a quick look. But what's also critical is the process for people or companies to object to what WorkSafe asks them to do.
Ah, okay. So there's a way to push back.
Yes. If someone's affected by a notice or a demand from WorkSafe, they have a right to object. They've got 15 working days to lodge a written notice with the district court. It provides a legal recourse, a check and balance for those who think WorkSafe's demands are maybe unreasonable or not warranted.
That's an important safeguard. But I see there's a critical exception to that objection process, which really hammers home the Act's focus on immediate safety.
Yes, that's right.
If WorkSafe decides a situation involves immediate danger to life or property, the objector must immediately take active steps to comply with the notice. The objection doesn't stop the need for immediate action then.
Precisely. Public safety takes absolute precedence in those critical situations. The Act gets that in electrical emergencies, time is vital.
Makes sense.
And furthermore, if an objection is lodged and it's not an immediate danger situation, the Act allows for assessors to be appointed. WorkSafe can appoint one, the objector can appoint another, as long as these people have special skill or knowledge relevant to the issue.
So experts can weigh in.
Exactly. It ensures that specialized expertise, like maybe an electrical engineer or an industry safety pro, informs the court's decision, leads to more technically sound outcomes.
Okay, moving beyond the routine stuff.
Hmm.
What happens when something actually goes wrong? The Act outlines mandatory protocols for accidents involving electricity. What counts as a reportable accident? Who needs to know?
Section 16 covers this very clearly. The Act mandates reporting for any accident caused, even partly by electricity or its generation, conversion, supply, use, basically anything electricity related.
Okay.
And this applies if it results in serious harm to anyone that includes death, loss of consciousness, or what's called a notifiable injury or illness.
What does notifiable injury cover?
Things like severe electrical burns, amputations, maybe injuries needing hospitalization. It's usually defined under broader health and safety laws. It also applies if an accident causes damage to any place that renders that place or part uninhabitable or unusable.
Right, major damage.
Yeah. And when an accident like that happens, there's a very strict rule about the scene.
And that's the rule about not interfering with the accident scene, right? You can't touch anything without permission from WorkSafe or maybe the police or fire and emergency.
That's it, unless, and this is the crucial bit, it's absolutely necessary to avoid or minimize further injury or damage or to restore the safe supply of electricity.
Ah, so there's a balance. Prioritize saving lives or stopping more damage, but otherwise preserve the scene for the investigation.
That balance is absolutely key. It allows for critical life-saving or damage control, but otherwise, preserve the scene for the investigation's integrity. WorkSafe can then conduct really comprehensive inquiries into these accidents, try to figure out the root causes, stop it happening again.
Makes sense.
And the Act also says owners or occupiers where the accident happened and anyone in charge must give WorkSafe all reasonable help they need. Facilities, assistance. It shows the collaborative yet authoritative role WorkSafe has. They need cooperation to do their job properly.
And what if someone doesn't cooperate? If they obstruct WorkSafe or hinder the investigation? The Act seems pretty clear about offenses and penalties for that.
Oh, very clear. The Act takes non-compliance incredibly seriously. There are specific offenses for obstructing WorkSafe when they're lawfully doing their job, refusing to hand over documents they need, or refusing to let them examine or copy docs, failing to supply information. These are all offenses.
Okay.
Intentionally damaging WorkSafe property used in an investigation is also an offense. And crucially, failing to notify accidents like Section 16 requires, or messing with an accident scene beyond those permitted exceptions that carry serious legal consequences.
So what does this all mean for, say, a company operating in the electricity sector? It sounds like WorkSafe has real power and the teeth to back it up.
It means exactly that. WorkSafe has substantial authority and the means to enforce it, backed by serious financial penalties. For obstructing WorkSafe, for instance, the fines are hefty, up to $50,000 for an individual or $250,000, $250,000 for a company. Yeah. It really underlines how seriously the Act treats compliance and cooperation with the safety regulator. These aren't just random numbers, they're designed as a significant deterrent. Reflects the potential for harm and the importance of letting investigations happen properly.
Okay, so WorkSafe is the watchdog. But what about the companies themselves, the ones owning and operating the actual power lines, the infrastructure that keeps everything running? How does the Act manage their role, especially around accessing land and roads for maintenance and building new stuff?
Right. If we connect this to the bigger picture, this part of the Act is really about balancing competing interests. It's a careful balancing act.
How so?
Well, it weighs the critical need for maintaining and expanding essential infrastructure, which we need for reliable electricity, against the fundamental rights of people who own land and property. It's about making sure power can be delivered and maintained efficiently, while still respecting property rights and, minimizing disruption. And this raises an important question about how the Act treats existing works differently from, say, building completely new lines. They have different rules.
Let's start with existing works then. Sections 22 to 23C. I read that quite clearly, landowners are specifically not responsible for maintaining existing electrical works on their property. Is that correct?
That is absolutely correct. Section 22A makes it explicit. Landowners are relieved of responsibility for maintaining existing works on their land. That job falls squarely on the line owner, the companies that actually own the infrastructure.
Right.
And to do that maintenance job, line owners get rights of entry onto land to maintain or finish off these existing works. But it's definitely not an unlimited right to just wander onto anyone's property whenever they feel like it.
Okay, so what are the rules around that entry? Do they have to follow protocols?
Oh, yes. They are legally required to give reasonable notice. Specifically, for maintenance or completing existing works, they need to give at least 10 working days written notice to the owner or occupier.
Written notice, okay.
And this notice isn't just a heads up, it's a legal requirement. It has to specify key details: the exact location, the reasons for access, what work they'll do, the date and time, and how long they expect to be there.
Pretty detailed.
It is. Now, for simply things like inspections or operations that don't involve major work, reasonable notice can be given in a less formal way, maybe a phone call or something similar. It's a bit more pragmatic for minor access needs. But that detailed written notice for actual work is key for respecting the landowner space.
But what about emergencies? Storms, down lines, critical faults, things that pose immediate risks. Does that 10-day notice still apply then?
Ah, that's a crucial distinction the Act makes. It has a very clear and sensible exception for emergencies. Prior notice isn't needed if entry is required because of probable danger to life or property, or if it's immediately necessary to maintain the continuity or safety of the electricity supply.
So public safety trumps the notice period in those urgent cases.
Absolutely. In those situations like a storm bringing down lines or a fault causing outages or shock risks, the immediate threat outweighs the need for formal prior notice.
But even then, in those no-notice emergencies, I gather they still have to notify the landowner eventually, maybe afterwards.
Precisely. Even in emergencies, the line owner must give notice to the owner or occupier as soon as practicable, and definitely no later than 5 working days after they entered. It shows the Act trying to balance that urgency with the landowner's right to know what's happening on their property. Ensures accountability even when things happen suddenly.
What if a landowner isn't happy with the arrangements? Say, they feel the conditions the landowner wants to impose are unreasonable. Can they challenge that?
Yes, they absolutely can. Landowners have the right to set reasonable conditions on the line owner's entry. The Act acknowledges their right to manage their own property.
Okay.
And if there's a disagreement about access or the conditions, the Act provides a clear path. Disputes can be referred to the Environment Court. The court's decision is binding on both sides, giving a definitive resolution. And importantly, the court can also award costs, which kind of encourages both parties to try and sort it out reasonably before going to court.
So that covers existing works on private land, but a lot of our power infrastructure runs along roads and other public areas. What are the rules for building and maintaining works on roads? That's sections 24 to 27 and 30.
That's right. Building or maintaining electrical works on roads is generally allowed because, well, we need a functioning grid. But this permission is subject to reasonable conditions imposed by the local authority or whoever has jurisdiction over that particular road.
The council, usually.
Often, yes. This framework is essential because it lets the road authority manage public spaces, effectively ensuring safety, minimizing disruption, while still allowing the vital utility work to happen.
And what counts as reasonable conditions? Is it just anything the council decides, or are there specific criteria they have to think about?
No, it's definitely not a free-for-all. The Act lays out specific practical criteria for reasonable conditions. Things like minimizing disruption to the public, keeping traffic flowing, not blocking access too much,
Okay.
ensuring safety for workers and the public, protecting public assets, the road surface, pipes underneath, coordinating with other utilities or roadworks to avoid digging up the same street multiple times, and, importantly, considering the electricity operators' need to get the network built or fixed in a timely, efficient way. It's a pragmatic list aiming for, a harmonious balance. And there's a really interesting detail about amenity values.
Amenity values. What's that?
Aesthetics, basically. If a condition from the local authority requires the operator to increase amenity values, say, putting lines underground just to make it look nicer, not for safety or operational reasons, and this significantly bumps up the cost.
Right.
Then the party imposing that condition, the council, usually has to pay that increased cost.
So the power company doesn't get stuck with massive bills just for cosmetic upgrades demanded by the council.
Exactly. It stops operators bearing unreasonable beautification costs that aren't core to the electricity works function or safety. It's a good example of the act balancing different public interests and figuring out who should pay.
That is a fascinating detail. Apart from conditions, is there a notice requirement for road work, like for private land?
Yes. Generally, notice must be given to the road authority before significant work starts, usually at least 10 working days. Unless, again, it's an emergency needing immediate action.
And failing to follow these roadwork rules is an offense for the operator.
It is. Failing to comply with Section 24 or 25 is an offense.
And what's the penalty for that?
An operator convicted of that faces a fine up to $10,000. And the court might also order them to pay compensation to whoever was affected by the noncompliance. So it's a punishment and making amends.
Can the electricity companies appeal these conditions or fines?
Absolutely. They have a right of appeal to the district court against any or all conditions imposed by the road authority. They need to lodge that appeal within 40 working days after getting the conditions formally notified. It gives them a fair review process. And one more point. While local authorities can charge for access to road reserves, basically rent for the space, the lines take up the Act says this charge cannot be a rate under the Local Government Rating Act.
So it's a specific access fee, not a property tax based on land value.
Exactly. Avoids putting an unfair financial burden on the network that way.
This sounds like a really thorough system for managing what must be a complex interaction. But what if existing lines, say overhead ones that were fine before, become a problem? Maybe they interfere with traffic now or pose a new hazard because of development. Can they be forced to move? And who pays? That's sections 32 to 35, isn't it?
Yes, they can certainly be required to move. A local authority or the authority controlling a road or railway level crossing can compel relocation if the works interfere with traffic or pose a danger. This power is crucial as communities change and grow. But as you hinted, the big question is often who pays for what can be very expensive moves.
Yeah. Who does foot the bill? Is it always the power company, or does the council pay if they're the ones wanting the move?
This is where the act gets nuanced again, trying to be fair. Generally, the party requiring the move pays the cost. So if a council needs to widen a road and the power lines are in the way, the council usually pays to move them.
Okay, that seems fair.
But there are exceptions. If the move is solely for the benefit of the landowner, maybe they want to build something where the lines aren't pinned to, then the landowner pays.
Right.
Also, and this is a key detail, if the works are moved and rebuilt to different specifications than the original ones, say, upgraded at the same time, the owner of the works, the electricity operator, only pays the difference in cost. The difference between what it would have cost just to move the old stuff and the actual cost of the new, different stuff.
So the council can't force the power company to pay for a massive upgrade disguised as a simple relocation.
Exactly. It prevents the requiring party imposing much more expensive upgrades entirely at the operator's expense, ensures a fairer cost allocation based on why the move is happening.
And can private landowners also get works moved on their land, even if it's not a big public project?
Yes, owners and occupiers of private land can also pursue moving works on their land, but it's not straightforward. It usually needs a court order, granted under specific conditions set by the court. These conditions would likely include compensation for the operator, ensuring it's a structured, legal process that respects the operator's existing rights and investment.
Okay, here's where it gets really interesting for me. Beyond the physical stuff, the lines, poles, substations, the Electricity Act puts a huge emphasis on the people actually doing the work. Electrical work is inherently risky, right? Needs precision, expertise. So who's allowed to do it? And what's the process for becoming a registered electrical worker? How does the Act ensure public safety on that human level?
You're right. This section is absolutely fundamental to public safety and the integrity of the whole system. It ensures that only people who've shown they're competent and who are held accountable can work with electricity. The Electrical Workers Registration Board, or just the board as the Act calls it, plays a central critical role in all this.
The gatekeepers, essentially.
Exactly. And this raises that important question about the standards that govern such vital work. How are they set, maintained, and enforced over time? It's not just a one-off check.
So the Electrical Workers Registration Board, the board, is set up by the Act itself. What are its main jobs? the big picture of what it's responsible for?
Okay, the board has really extensive, crucial responsibilities. It's empowered to designate the different classes of registration for electrical workers, sort of categorizing them by expertise and what they're allowed to do.
Like domestic versus industrial, maybe?
Things like that, yes. It sets the terms and conditions for getting registered in the first place and for keeping your practicing license current. They carefully consider all the applications, checking qualifications and character. Critically, they actively promote ongoing competency, making sure skills stay sharp in a field that changes fast. The board is also the main body for hearing complaints against electrical workers and running disciplinary proceedings. That gives them real teeth for oversight and enforcement. They can even initiate prosecutions for serious breaches of the act, and they have to report regularly to the minister, ensuring government accountability.
Wow, that's a lot.
And what's really fascinating is that the Act actually requires the board to review how the Act itself is operating well, the parts relevant to workers, not the broader market stuff every 5 years, and report back to the minister.
So the act requires its own checkup.
Pretty much. Ensures the legislation stays current and effective, adapts to new tech and practices. The board itself is made up of members appointed by the minister, chosen for their expertise, and it operates formally with its own seal and publishes an annual report, so there's public transparency.
That's incredibly comprehensive. Let's dig into how they actually classify and license workers. How does the board decide on these different classes of registration? And then how does someone actually get their practicing license? We're looking at sections 84, 85, 91, 93, 98, 99, 103, and 106, 107 here.
Right. The board designates these classes of registration by formally publishing a notice in the Gazette.
The official government publication.
Exactly. This notice spells out, with legal clarity, precisely what prescribed electrical work someone in that class is allowed to do and under what specific conditions. It's vital for segmenting the industry by expertise, making sure electricians are qualified for the specific work they do, whether it's wiring a house or maintaining a substation.
And what guides the board when making those designations? It can't just be random, surely. It must be safety-driven.
Absolutely not random. The Act lays down clear principles. These classifications and conditions must be demonstrably necessary to protect public health or safety, prevent property damage, and actively promote competency among everyone doing or helping with prescribed electrical work.
Okay.
And before they publish these notices, the board must consult widely with worker representatives, industry bodies, other affected groups. This consultation ensures industry perspectives and practical realities are considered, making the designations effective and workable.
So once the classes are set, how does Joe or Jane electrician actually apply and get their registration and license?
The application process is thorough. You apply to the registrar, who sends it to the board. The board then meticulously checks if you meet the minimum standards, the specific competence requirements for the class you want, maybe exams, practical tests, verified experience, and crucially, if you're a fit and proper person to be registered.
Fit and proper, what does that involve?
It goes beyond just technical skill. It looks at character, reliability, honesty, any past conduct that might suggest a risk to public safety. It's a character check, basically.
Yeah.
In some cases, the board can issue a provisional license. Maybe while a full application is processed, or if someone needs more supervised experience, it lets them work, but under controlled conditions.
Okay.
Once a full practicing license is issued, it comes with conditions, standard ones for that class, or maybe specific ones for that individual, perhaps based on experience or past issues. And these licenses usually need renewing every 5 years.
Every 5 years.
Yep. And renewal depends on meeting ongoing competence requirements, maybe doing refresher courses, proving your skills are still up to date with new tech and safety standards.
Are there any situations where someone might be exempt, maybe for really specific low-risk stuff or in certain industries?
Yes, the board can grant exemptions, either for specific individuals or for a whole class of persons from the usual registration and license rules. This allows flexibility for unique situations, maybe highly specialized industrial settings with strong internal safety systems or certain research work. But any exemption is considered very carefully to make sure safety isn't compromised.
Now, beyond individual workers, the Act also talks about employer licenses.
Yeah.
What are these? Why are they needed? How do they add another safety layer? That's sections 114, 115, and at 120, 123.
Employer licenses are a really crucial proactive safety layer. They shift some responsibility from just the individual worker onto the organization they work for.
Right, the company level.
Exactly. An employer license requires the employer to set up and maintain a robust safety management system. And this isn't just a policy document gathering dust. It has to be demonstrably good enough to ensure all their employees doing prescribed electrical work are competent, get the right supervision and training, and do their work safely and competently, following the Act and regulations. It's about embedding safety structurally within the company.
So it's not just about the worker's skill, but the employer's system for ensuring safety across their whole team.
Precisely. The employer license holder is ultimately responsible for making sure all prescribed electrical work done by their employees complies with the Act and regulations. It broadens accountability significantly. It recognizes that safety is a shared thing, heavily influenced by the company culture and systems. And, just like with individual licenses, the board has real power over these employer licenses too. If an employer fails to meet the license conditions, or critically, fails to ensure their employees' work is safe and competent, the board can cancel that license or impose stricter conditions. It's a strong enforcement tool for systemic failures.
And can the board inspect these employers to check they're complying, like WorkSafe does?
Yes, they can. Employer licenses come with a condition allowing authorized people from the board to inspect the employer's premises, though usually not dwelling houses without a warrant at reasonable times, for an authorized purpose.
Yeah.
And during these inspections, they can demand documents to check compliance with the license terms. This lets the board verify that the work done by employees is safe, competent, and follows the rules. It's an essential oversight check to protect the public.
Okay, let's unpack this further. We know who can do electrical work, but what exactly is prescribed electrical work? And what are the really strict rules around actually doing it? And crucially, what happens if those rules get broken? This is where the Act really ensures accountability and maintains those high safety standards.
Yeah, this is really where the rubber meets the road, as you put it. The Act carefully defines specific types of electrical work that need stringent control because of the risks involved. This prescribed electrical work covers anything regulations deem hazardous enough to need special precautions, proven competency, or formal certification.
Wow.
And precisely because of those risks, there's a robust system for holding individuals and companies accountable if they mess up. And this brings up that important question. How does the system not only find and fix incompetence or negligence after the fact, but actually try to prevent harm before it happens? Safeguarding the public is the core goal.
So given those risks, who exactly is allowed to do this prescribed electrical work? Are there exceptions maybe for apprentices or people working on their own homes? That's section 74 to 83, right?
Generally, yes. Prescribed electrical work has to be done, or at least assisted, by a registered person with a current practicing license that specifically covers that type of work. That's the baseline. But the Act does allow for some practical, carefully defined exceptions, like people doing work for themselves on their own property as long as it's their main home and not for commercial gain.
DIY, but with limits.
Exactly. It also includes trainees working under the direct, competent supervision of a qualified, registered person. And finally, those specifically exempted by the board for unique situations. But these exemptions are narrow, ensuring the core principle of safety oversight isn't weakened.
And what are the critical safety rules during the work? Especially about connecting to live power. That sounds like a huge no-no.
It is. A crucial rule is that generally no part of the work should be connected to a power supply while it's being done by someone under supervision, like an apprentice, prevents live work accidents.
That makes sense.
Furthermore, all prescribed electrical work must be rigorously tested and certified according to detailed regulations. This has to be done by a registered person whose license specifically allows them to test and certify that kind of work. And this testing must happen before the work is connected to a power supply.
So test first, power up later. Always.
Always. That pre-connection testing and certification is non-negotiable. It ensures the installation is safe and compliant before it gets energized. It's often documented on an electrical safety certificate or certificate of compliance.
And who's responsible for making sure that certification actually happened before flicking the switch, so to speak?
Good question. A person or company must not supply electricity to any works or installation unless they are satisfied that any inspection and certification required has been carried out. This puts the onus on the electricity supplier to check for compliance before energizing.
Okay.
The only exception is supplying power solely for testing, inspection, or certification purposes. That allows the safety checks themselves to happen with power, but under controlled conditions.
And to make sure these strict rules are followed, does the board have entry powers like WorkSafe to actually check the quality of work being done.
Yes. The board has significant oversight powers here, too. It can authorize entry into any premises, including a dwelling house, at any reasonable time.
Even someone's home.
Yes, but for a dwelling house, they need to give prior notice to both the owner and occupier, and the authorized person has to show their ID and warrant of authority. The specific purpose is to inspect and test prescribed electrical work on the premises that is, or is intended to be, connected to power. They can also ask questions to see if it's been properly tested or certified, and they can do this proactively, even without suspecting bad work, emphasizing a compliance-focused approach.
So what happens if someone does break these rules? The Act lays out disciplinary offenses and proceedings in Part 11, Sections 141 to 147M. What kind of things count as a disciplinary offense?
The range is quite broad, reflecting all the ways things can go wrong. Examples include doing electrical work in a negligent or incompetent manner, or doing it contrary to the rules or regulations.
Okay, poor workmanship.
Yes. It's also a serious offense to intentionally or negligently create a risk of serious harm to any person or a risk of significant property damage. This could be through using faulty fittings, knowingly hiding shoddy work, or just doing a poor job that creates a hazard. Other offenses include not following the conditions on your license, doing work you're not authorized for, intentionally deceiving a certifier, maybe hiding bad work during an inspection, or lying on a certificate, or even an employer knowingly getting an unauthorized person to do prescribed work. It covers a whole spectrum, from individual mistakes to deliberate deception and employer failures.
That covers a lot, from negligence to outright fraud. How does the disciplinary process work once a complaint is made? How is fairness ensured?
The process is structured. Complaints are first looked into by an investigator appointed by the board. This investigator has powers to enter premises and gather information.
Okay.
They then report back to the board on whether the complaint seems serious enough to warrant formal disciplinary action. If the investigator thinks it should proceed, the board must hold a formal hearing. Yes. And the person being complained about must get not less than 20 working days notice of this hearing. Plenty of time to prepare. And critically, they must get a fair chance to be heard either themselves or through a lawyer to present their side. And there's something really important called interim suspension or disqualification.
What's that?
If the board genuinely believes there's an immediate serious danger to public health or safety, or a big risk of property damage while a complaint is being investigated, they can suspend the person's license or registration immediately.
Wow, straight away.
Yes. This order stays in place until the complaint is fully resolved. It's a powerful tool to stop potential harm quickly without waiting for the full hearing process.
That's a strong safety net.
Yeah.
And if, after the hearing, someone is found guilty, what can the board do? What are the penalties or consequences? The Act seems to give them a lot of options.
It does. The board has a very wide range of disciplinary powers under Section 147. They're designed not just to punish, but also to deter and ensure future competence. They can take severe action, like canceling someone's registration or license entirely, including provisional or employer licenses.
Right.
They can order that the person can't reapply for registration or a license for a set period, effectively banning them temporarily. They can suspend a registration or a license for a set time, or even permanently for serious offenses. They can impose specific conditions on a license, maybe restricting them to work only on certain types of premises, or only for an approved employer, meaning closer supervision. They can disqualify someone from doing prescribed work permanently or for a time. Or they might require the person to do a competence program, get more training, or pass an exam to prove they're competent again.
So retraining is an option.
Yes. And finally, they can impose hefty fines up to $10,000 for an individual or $25,000 for a company reflecting financial accountability. And on top of all that, the board can also order the guilty person to pay the costs and expenses of the investigation and hearing.
So they pay for the process that found them guilty.
In effect, yes. It means the public doesn't solely bear the cost of investigating misconduct. Adds another layer of financial accountability.
And once a decision is made, is it kept secret? Or can the public find out? And can these decisions be appealed even after the hearing?
The board can publish the outcome of disciplinary decisions, often at its discretion. This usually includes the reasons and the person's name in the Gazette and maybe other publications. This transparency informs the public, reinforces accountability, and might guide hiring decisions. And yes, there's definitely a right of appeal to the district court. If someone's unhappy with a board decision like refusing registration, suspending a license, imposing conditions they can appeal within 20 working days. And for tricky legal points, appeals can even go higher, to the high court. So what does this all mean? It's a comprehensive system aiming for high standards, addressing misconduct, but with clear paths for appeal. It tries to be both rigorous and fair, all serving that critical goal of public safety.
Okay, shifting gears slightly. The Act isn't just about inspections and individual workers. It also sets the stage for broader regulations and safety systems impacting the whole sector. What are some of these bigger picture requirements ensuring safety from the top down?
Right. This part of the Act really pushes preventative measures and systemic safety. It's a key shift from just reacting to problems to proactively managing risk. And that's absolutely critical in such a large, complex, high-risk industry like electricity, where one systemic failure could be catastrophic. If you connect it to the bigger picture, it's about building a safety culture right from the ground up, making sure sophisticated, documented systems are in place and constantly checked long before anything bad happens. It's about designing safety into how things operate.
So what kind of standards are we talking about for the actual electricity supply and all the equipment involved? Section 60, 61, 169, 169B seem relevant here. How does the Act ensure the quality of the power and the gear carrying it?
Okay, first, all electricity distributed by a distributor has to meet prescribed standards. Ensures consistency, reliability for consumers. Second, and this is crucial for safety, all works the poles, lines, infrastructure, plus electrical installations in buildings and appliances must be of such quality and standard, and built, maintained, and operated according to such safety requirements as are set out in regulations.
So the Act sets the principle and regulations fill in the technical details.
Exactly. These broad statements allow for specific technical regulations covering everything from insulation levels to earthing requirements. Ensures high safety standards right across the supply chain, from the power station to your wall socket.
And how are these detailed rules actually made? Does the Act give broad powers to create regulations covering all these specifics?
Yes, it grants the Governor General, acting on advice, extensive power to make detailed regulations on a huge range of things, shows the deep reach of the Act. This includes prescribing the classes of registration and licenses, setting technical standards for work practices, recognizing overseas qualifications, setting fees, mandating forms,
Right.
and significantly, it allows for infringement offenses. These are basically minor breaches handled with fixed penalties, like a parking ticket, avoiding a full court case. The fees are capped max $1,000 for individuals, $3,000 for companies. Makes enforcement for smaller things more efficient.
It sounds incredibly detailed, even down to trees.
Mm.
I noticed the sources mentioned controlling vegetation. How does that fit in, and why is it important?
That's a great practical example of the Act's reach. The Governor General can make regulations for controlling the existence and location of any tree or vegetation that is in the vicinity of or may affect any works or electrical installation.
So rules about trees near power lines.
Exactly, including requiring trimming or removal and deciding who pays. This is vital because vegetation, overgrown branches, dense bush is a major cause of outages, line damage, even fires, especially in storms.
Right.
By allowing proactive vegetation management, the Act helps ensure network reliability, reduces disruption risks, and boosts public safety. It's about stopping nature from causing electrical problems.
Beyond specific rules, what about safety management systems, or SMS?
Yeah.
Section 169A seems to make these mandatory for key players like generators and distributors. What do these systems involve?
SMS are mandatory, and they're a cornerstone of preventative safety for generators and distributors. The regulations must require the systematic identification of existing hazards and proactive identification of new hazards, ideally before they become problems.
Okay, find the risks. Then what?
Then the system must outline how these hazards will be eliminated, isolated, or minimized so far as is reasonably practicable. It's not about zero risk, but taking all reasonable steps to control it.
Right.
Key parts of an SMS also include regularly assessing each hazard to understand the risk, thoroughly documenting the whole system for clarity and accountability, and crucially, regular audits of the SMS to ensure it's working effectively and to find ways to improve it. It's a continuous cycle. Plan, do, check, act.
So it's about constant vigilance and improvement. What specific areas might these SMS regulations cover in practice?
Oh, a very wide range. Things like the design of new infrastructure, construction methods, operational rules for managing the network, routine maintenance schedules, equipment inspection regimes. They could also cover strict protocols for handling incidents, faults, crises, and for thoroughly investigating any accidents or near misses involving the supply system, so lessons are learned.
Okay.
And what's fascinating here, a key legal point, is the Act explicitly says a person only has to take action for circumstances they know or ought reasonably to know about.
So there's a reasonableness test.
Exactly. It sets a clear standard of diligence. You can't be held responsible for totally unforeseeable events, but you must act on what is, or reasonably should be, within your knowledge and control.
We've talked about powers of entry for WorkSafe and the board. Are there general conditions covering most of these powers, like in Section 159, to ensure they're used properly?
Yes, there are overarching general conditions that apply to most entry powers under the Act, unless a specific section says otherwise. Ensures consistency and protects rights. Entry must always be by a specified or authorized person.
Okay.
They must carry a warrant of authority or official ID and show it if asked. Reasonable notice generally has to be given before entry, unless doing so would defeat the purpose, like if evidence might be destroyed. Entry must also be at reasonable times, respecting privacy and working hours.
And what about entering private homes, dwelling houses? Is that allowed under these general conditions? Are there stricter rules?
Critically, yes, there are stricter rules. Entry into a dwelling house must be authorized by a warrant issued by an issuing officer. That's usually a judge or a justice of the peace.
So you need a judge's permission to enter someone's house for this?
Yes. It means a higher level of judicial oversight is needed before authorities can enter a private home for inspection or compliance. Ensure such intrusions are justified and legally sanctioned, a vital safeguard against arbitrary access.
Finally, let's talk general offenses and penalties. Beyond the disciplinary stuff for specific misconduct, what broader actions attract big penalties under the Act? How tough are they? This is Sections 160, 163D.
Right. The Act has serious penalties to deter a wide range of noncompliance. For instance, making false declarations or representations to get registered, get a license, or a certificate that's a serious offense, liable to a fine up to $10,000. Crucial for maintaining the integrity of the system.
And what about pretending to be qualified when you're not? Misrepresentation.
Also a clear offense. Claiming to be licensed or registered under Part 10 when you're not, or deceptively suggesting someone else is qualified, or misusing certificates or licenses, all prohibited. Fines up to $10,000 for that too. Protects the public from unqualified people doing dangerous work.
So just doing prescribed electrical work without being authorized working outside your license, what's the penalty?
Doing prescribed electrical work in breach of the Act, like work you're not qualified for, is a fundamental offense. Fines up to $10,000. Reinforces that core need for qualified people on hazardous tasks. And for employer license breaches, where an employer doesn't meet their license conditions, maybe fails on their safety system or supervision, the fines jump significantly, up to $50,000 for an individual responsible, or a huge $250,000 for a company.
Quote $1 million.
Yeah. Reflects the greater systemic responsibility on employers. Their failures can affect many people.
And lastly, the most severe penalties. For actions or omissions that could actually cause serious harm or major property damage, what's the ultimate deterrent?
The Act saves its biggest penalties for actions or omissions likely to cause serious harm or significant property damage. For those grave offenses, individuals face fines up to $250,000, and companies can be liable for fines up to $500,000, $500,000.
$500,000.
Yes. So what does this all mean when you look at the penalties overall? The Act isn't just about setting standards, it has real teeth. These substantial penalties aren't just punishment, they're a powerful deterrent. They reinforce the absolute seriousness of electrical safety and the potentially devastating consequences, human and financial, of getting it wrong. Underscores the vital importance of diligence and responsibility in this high-risk industry.
So what does this all mean when we pull back and look at the whole thing? This deep dive into the Electricity Act 1992, it really shows that what seems like maybe a dry, technical document is actually this incredibly robust, adaptable framework. It's meticulously designed, isn't it, to protect lives, prevent damage, make sure the vital flow of electricity stays safe and reliable for all of us. It feels like a living set of rules, constantly adapting.
Indeed. You go from the broad powers of WorkSafe to investigate and enforce, right down to the detailed requirements for electrical worker registration, the ongoing competency checks, and that fundamental emphasis on systemic safety management systems for the big operators. The Act really touches every single part of the electricity supply chain.
Yeah.
It's a testament really to the fact that knowing the rules isn't just about knowing what they are, but understanding why they matter. In this case, why all these intricate regulations exist to proactively manage the inherent risks in a complex, vital industry we all depend on every single day. If you connect it to the bigger picture, it just highlights that constant, often unseen effort happening behind the scenes to maintain incredibly high standards and ensure accountability.
Absolutely. It's a fantastic example of how these foundational legal frameworks just quietly underpin our everyday safety and convenience, often in ways we don't even consider until, well, until the lights go out, or worse. For you, the listener, understanding these layers of protection, it really can give you that aha moment about the unseen infrastructure enabling our modern world. It certainly shifted my perspective.
And this raises an important question for all of us looking forward. In a world that's just increasingly reliant on electricity for, well, everything, essential services, daily conveniences, how might future changes to acts like this continue to evolve? What new challenges will emerging tech like, say, advanced smart grids or more distributed energy generation pose to these core principles of safety and accountability? And how will the law adapt while still holding on to that fundamental protective role?
That is a really thought-provoking question to mull over. How do you keep safety paramount when the technology itself is changing so rapidly? Until next time, keep digging, keep questioning, and keep deep diving into the fascinating world around us.